खिशात नाही.
तुमचं काय आहे काय?
इधर का नहीं इधर वो
इधर तो पूरा वायरा वायरा हो गया.
तीन विषयाची माणसं आम्हाला काही चिंता नाही.
तुझं पुस्तक घेतलं बाबा प्रश्नपत्रिका काढायला.
आमचे आता ही पहिले हे नंतर प्रश्नपत्रिका काढणं अध्यक्ष शेड्यूल काय केलं. ते झालं मला ते टीवायचे पण प्रश्नपत्रिका काढायचं. मला ते शेड्यूल करून दिलं.
हॅलो अनंतर सर
आज येते का?
अरे मला पहिले सांग
काय विषय
तुमच्यासारखं इंग्रजी करणं आमच्यासारखं काय करावं.
हा म्हणून म्हणते ना
हाँ अनंतर सर.
हॅलो
हॅलो सर. सर आवाज येतो का? मला येतो. आवाज आवाज नाही येत सर तुमचा.
हॅलो.
हा हा येतो येतो. माझा आवाज येतो का क्लिअर?
मॅडम मला आवाज येतो. हो हा येतोय ना. हा ओके.
प्रिन्सिपल सरांना फोन करा.
असं ना. जॉईन किती झाला तुम्ही?
जॉईन तर मी तिथं बसतो.
नाही तिथूनच सरांना फोन करतो जॉईन.
त्यांना पाठवले
असं
हॅलो सर.
चालू असताना कारण इकडे खरंच
सर त्यांना म्यूट करायला सांगा मग बोलते.
मॅडम बोला.
आवाज नाही.
हॅलो, गुड मॉर्निंग.
गुड मॉर्निंग मॅडम.
Good morning, madam. Just wait for 5 minutes. Our principal sir will join and then we will begin, ma'am.
हा मॅडम को होस्ट करा म्हणजे मी मोबाईल वरून एकदा जॉईन.
Yes, ma'am. Yes, ma'am. करते. हा.
एक वेळेस
हे बघा हे मी तर असं ठेवतो म्हणजे तुम्हाला लाईव्ह दिसत तुम्ही काय बोलताय काय नाही बरं का मॅडम तुम्ही जे काय करताय ते सगळं तुम्हाला इथं ऑनलाईन दिसेल.
त्यांना कोर्स केले अजून
मॅम को होस्ट केलं.
ओके ओके.
अॅनोटेशन्स वगैरे ते बंद करायला
दुसऱ्या डिव्हाइस वरून जॉईन होतो मॅडम.
ओके ओके.
अॅनोटेशन्स वगैरे मॅडम ते बंद करायला अॅनोटेशन्स
ते सांगते आधी सरांना जॉईन करू. त्यांना काय करू.
याचा आवाज बंद करू पाहिजे.
कसं काय कॉल करू.
कॉल करा की त्यांना तुम्ही चेअर पण आहे. कॉल करा.
हा मोबाईल घ्या त्यांना ऍड करा पार्टिसिपेट ऍड करा
सर्व असल्या करतील
त्यांना सांगतो.
सर्व लाईन व्यस्त आहे.
इथून लावा. काय आलं लिंक नाही आले का बरं एक मिनिट या अरे फोन पण बंद ठेवावं लागेल आपल्याला. राहू
कोणी आवाज
कसला इथला गुड मॉर्निंग सर, आवाज येतोय?
बाकी सगळ्यांचा ऑडिओ बंद आहे का ते बघायला
मॅडमचं आहे ना, हे करावं लागेल.
काय
Am I audible, sir?
Yes, sir. Are audible.
हॅलो,
हा साहेब, तुमचा आवाज येतोय.
येतोय ना?
हो, माझा येतोय?
हो, येतोय येतोय.
ओके ओके सर. थोडीशी म्हणजे नाशिकला जाणार बाईक घेणार. येस.
Good morning and
दार बंद कर.
good morning and very warm welcome to all the dignitaries, resource person, faculty members, researchers and students. Myself, Dr. Neha Desai, Assistant Professor in Chemistry and Chairman for the IPR cell, RBNB College, Srirampur. We have gathered here for the online webinar entitled Intellectual Property Rights, organized by IPR cell in a collaboration with the IQSC RBNB College Srirampur. This webinar is not possible with the motivation and the encouragement by Honorable Minatai Jagdane, Member Management Council, Rayat Shikshan Sanstha and Member CDC, RBNB College Srirampur. Our principal, Honorable Dr. N.S. Gaikwad sir, is continuously guiding us and supporting us to conduct the webinar. With this introduction, now I request Honorable Dr. N.S. Gaikwad, Principal, RBNB College, Srirampur, to give the inaugural address.
Good morning to all of you.
Good morning, sir.
I'm very much happy to be here with you all people, including the resource persons, all the participants with whom we are governing this type of seminar is Dr. Neha Desai Madam, Dr. Anandkar, and all the participants as well as colleagues. So, as far as the intellectual property right is concerned, so we have requested Daya Patil Madam as a resource person. She is research guide and librarian of SBES College, Aurangabad. Madam, I welcome on behalf of Rayat Shikshan Sanstha and Borauke College. As far as the intellectual property is concerned, so the topic is very important topic as far as we consider the things related the property. So we consider property as the tangible assets. So tangible assets and intangible assets. So tangible assets, we know that house, car, maybe your computer, all these are tangible assets. And intangible assets, that means some intellectual things. For example, some kind of design we do have, some kind of music we have prepared, any kind of things which is related to the intellect. We are using that intellect, and with that intellect we can have some copyright of the material, copyright of the music, copyright of some figure or anything, copyright of the books. So these kind of things may happen in this IPR type of movements. So it is very important that the students, they should be aware of the intellectual property rights, how to file the patents, how to file the copyright things. So we will be guided by the eminent speaker Daya Patil madam, and we know that all types of innovations, all types of designs, even if we have some symbols, if we have some marks, if we have some names, we have some images. So all these can be considered as the intellectual property. There are also some kind of things that trade related intellectual properties are also there. So we can file some patents related to innovative products, innovative processes. We can also file patents related to the designs, some creative designs or some kind of things. For example, if we have designed some solar operated car, so we can have our own patent with that type of design. So these are the basic things related to the intellectual properties. And as we are all working in higher education sector, so mostly in traditional colleges, just like arts, commerce and science colleges, maybe we are also having some support of this BCS or MCS or some computer type of departments, or maybe some kind of professional courses we are running. Still we are unaware of these kind of things related to the patents and copyright things. So this is very right time and this is right occasion to be known with the ideas about the intellectual property rights as well as the copyright of things. And we are all fortunate to be here in this auspicious gathering of the intellectual property right with eminent speaker Patil madam, as well as all the participants and resource persons linked with this intellectual property right seminar. I welcome all the participants and dignitaries on behalf of Rayat Shikshan Sanstha, on behalf of Rayat Shikshan Sanstha's management, Honorable Minatai Jagdane. She is member of Rayat Shikshan Sanstha's managing council. She is also heading as the chairman of Borauke College. And I also welcome and I declare on behalf of Minatai Jagdane that this webinar is inaugurated. I again welcome all of the participants and I especially welcome Daya Patil madam to be here with us to share her views. Thank you very much.
Thank you very much, sir, for the inaugural address. Intellectual property is a category of property that includes the intangible creations as said by our honorable principal, sir. Actually, the concept of IP, that is intellectual property, it was developed in the year of 18th century in England, and then actually the term intellectual property began to be used from the 19th century. So with this brief introduction, it is my great honor and pleasure to introduce our today's resource person, Dr. Daya Trambak Patil Madam, currently working as a research guide and librarian at SBES College of Science, Aurangabad. She has administrative experience over 25 years and research experience of 19 years. She has many awards and prizes to her credit. She has got Ravi Painter Ranjan Gaonkar Gold Medal. She has got Shri Ananta Narayan Gore Prize, Prabhakar Bhalerao Smruti Paritoshik. She has also got Dr. V.N. Walivadkar Prize. She also won Kartutvan Mahila Nari Ratna Gaurav Puraskar in the year 2017. She has also won Kailaswasi Supra Satarkar Utkrishta Mahavidyalayan Granthapal Puraskar in the year 2020. She has published more than 102 research articles. She has guided 25 students for the MPhil and 10 students for the PhD. She has delivered more than 19 invited lectures. She has published one book and she has edited 3 books. So such a highly knowledgeable person is with us today. So I request her to start with her presentation. Over to you, ma'am.
Am I audible, madam?
Yes, ma'am.
First of all, thank you very much, madam, for very good introduction and brief introduction of myself. Very good morning, friends. Chairperson of the webinar and chairperson of the Rayat Shikshan Sanstha, Jagdane madam, honorable principal of Borvoke College, Dr. Gaikwad sir, authorities and members of IQAC and IPR cell, organizing team of the webinar, my friend Dr. Anankar sir and Dr. Desai madam, all dignitaries attending this webinar, very learned audience present over here to attend this webinar, various principals of various colleges, professors of various subjects, librarians, and my professional friends. Very, very good morning to one and all. First of all, I am very much thankful to the principal and organizing team of Boroke College for giving me an opportunity to discuss with you on the topic IPR. Friends, during last 6 to 8 months in this pandemic situation and lockdown period, all of us are attending number of webinars and organizing also number of webinars. But till the topic selected or theme selected by Boroke College is a very nice thing, because this is the need of the day, that there should be a discussion on the topic like IPR. So I will discuss the topic. I'm going to share my screen for the presentation of this webinar, IPR. Friends, the outline of my presentation is the introduction about the theme, that is intellectual property rights. What are the branches of IPR? What are the recent issues of IPR? And what is the Indian policy about the IPR policy. IPR is the legally recognized exclusive right to creation of the mind. Intellectual property refers to creation of mind such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. IPR is an intangible asset, general term covering what IPR consists. It consists patents, copyright, trademark, industrial designs, geographical indication, protection of layout design, and undisclosed information like trade secrets. Is there a need to protect intellectual property? Yes, there is a need because IP is creation of human mind. Like tangible property, it has a value, so it needs to be protected. IPR gives IPR gives the protection to IP, intellectual property, as well as helping them from exploitation and control their IP. Use or value of expressed idea is protected. Yes, there is a need because it has a value, it is company value for entry barrier, for a legal monopoly, to avoid violation, for financial benefits, for advance of mankind, for goodwill, for work of arts, and should not be fake or should not be copied. There is a need to protect the intellectual property. IP rights can be categorized in two, that is registered and unregistered. Rights
इथून मी
are
फोन
given
लावले अजूनही लावला
to the owners
मी जर इथून फोन
or
लावला अजूनही लावला
rights are given to the owners or holders may be broadly categorized in two sections, that is registered patents, trademarks and design rights are come under the category of registered IP, and copyright, unregistered design rights, common law, trademarks, database rights, protection for how under law deals with confidential information like trade secrets, plant varieties, geographical indications, designs and symbols, or trace legislation. These are come under the unregistered category of IP rights. Then we come to the what is the intellectual property right. Intellectual property right give the protection for IP. This is the most important factor, that IP has to be protected. IP has to be protected some legal concept, and that is the IPR. Intellectual property is an intangible creation of human mind, usually expressed or translated into a tangible form that is assigned creation rights of property. It refers to the legal ownership by a person or business of an invention attached to particular product or processes, which protects the owner against unauthorized copying of imitation. Intellectual property rights are the statutory rights once granted allows the creators or owners of the intellectual property to exclude others from exploiting the same commercially for a given period of time. It allows the creators or owners to have benefits from the work when these are exploited commercially. IPR are granted to an inventor or creator in lieu of disclosure of his or her knowledge. What it means? It means the exclusive right granted by state to prevent others from using, manufacturing, distributing the inventions and processes of the individual or group of individual or any institution or any company. What are the types of IPR? These are the types: patent, trade secrets, copyrights, trademarks, design, geographical inductions, breeding. These are the types of IPR. Today's application and new original design trademarks, new plants, varieties, databases, and artistic and literary work. Such a person is known as a rights owner or a rights holder. Today's webinar's audience is the professors or the stakeholders which are uh, doing the job in the higher education sector, and related types of IPR to this audience is copyrights and patents. Patents for pure science, copyrights for social science, also for science and commerce. So maybe these are the types of IPR. We shall cover in detail two of them, that is patents and copyrights, and others we will brief in short other types of the IPR. What is the intellectual property right? The term IPR refers to the following categories. This is the international scenario of IPR, about the IPR. The 1 to 7 sections of the part second GATT 1994 Act, 7 sections are given, and these are section 1 for copyright, section 2 for trademarks, section 3 for geographical indications, section 4 for industrial design, section 5 for patents, section 6 for layout design, and last one, section 7 deals with protection of undisclosed information. We call it as trade secrets also, because it's not the open for society. It's a confidential information that also should be protected by the IPR. And this is the international scenario according to the GATT 1994. In last slide, we see that there are these types of intellectual property, that is patents, trade secrets, copyrights, trademarks, design, geographical induction. So we will see one by one what are these, what it differentiates from one another. These are the branches of IP. Today's audience are a professor, so we will discuss only two in detail and another in short. So first of all, we see the patents. What are the patents? It is a monopoly right granted to a person who invented a new product or process of making an article. A patent is an exclusive right granted by law to applicants to make use of and exploit their invention for a limited period of time. Term of patent is 20 years from the filing. The patent holder has the legal right to exclude others from commercially exploiting his invention. In return of exclusive rights, the applicant is obliged to disclose the invention to the public in a manner that enables others skilled the art to replicate the invention. The patent system is designed to balance the interests of applicants and the interests of the society. The inventor has to file the patent first and then make his or her invention to the public, maybe individually or maybe with the help with the group of scientists or by the any company or by any institution also. Isolated, these are some patentable uh, patents which are areas in which the patents are can be filed or a patent has been awarded. That is isolated polynucleic acid, peptides and polypeptides, enzymes, microorganisms, viruses, vectors, antibodies, probes, vaccines, compositions, expression systems, cell lines, plants, seeds, organisms, methods for preparation or use. A patent application can be filed online or offline at respective patent offices, which has specific territorial jurisdiction in that particular country. Territorial jurisdiction is decided by place of residence of application, applicant, or place of invention. This jurisdiction is decided as per the where that particular individual resident or what is the address of the office in which he is working and filed the patent, or address of an office given by the foreign applicant. From these areas, patent can be filed. In India, there are 4 offices to file the patents as per the territorial jurisdictions. Mumbai is the patent office for Gujarat, Maharashtra, Madhya Pradesh, Diu and Daman, Dadar and Nagar Haveli. Delhi is the patent office for the region Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan, Uttar Pradesh, and Delhi. Chennai is the head office to file the patent for the state Andhra Pradesh, Kerala, Telangana, and Lakshadweep. Rest areas or rest states of India can file the patent at the head office of patent, that is Calcutta. These are the bifurcation region-wise for to file the patent in that particular area. The patent, what is the need to get the patent? There is an Act of Patent, that is 1970. The Patent Act. Conditions to be patented is novelty, inventiveness, and usefulness. These are mandatory factors to file the patent, essential factors to file the patents. Patenting invention should be novel or satisfy able improvement in old patent. There should be the considerable improvement in the old patent, then and then only you can patent the file about that product or that process. So novelty is very important factor to be patentable. Inventiveness is also a most important factor because a patent should be inventive. It should be decided on the material content in unpublished patent. Usefulness is also a most important factor to get it patentable because useful information must possess utility for grant the patent. These three factors are essential to get patented by the Act 1970 of the patents. Prior art, public domain, public use. Prior art, something which was already known to mankind. Anything which was already known in general or a specific group of persons, whether in the same country or abroad, cannot be patented. What do you see? There are three factors, that is novelty, inventiveness, and usefulness are required to get it patentable. Is it? And this one, which information is already known to the society, already known to the persons or group of persons, whether in the same country or abroad. Not necessary to be in that country only, maybe in abroad, cannot be patented. Then we will see in India how patents are filing. In our audience, yesterday only I know that the organizing committee member, they say, Madam herself get a patent. She knows, our audience also knows how to get patented or how to file the patent. But it is a mandatory factor that this theme of the webinar, considering there is a need to enlighten how to file the patent in India. First step in patenting in India is filling the application. On the date of application is filed, it is numbered. At that only, on the same day or on the same date, it is numbered when the file has been submitted by the applicant. Second step to get the patent is meeting procedural objections. Generally, within a month of filing the application, the patent office sends a preliminary objection letter which has to be compiled within a specific time limit. Third step is publication for examination. Application is published in the official gazette and is open to public after 18 months. It time takes 18 months from the date of priority of the application. Whichever is earlier, that date has to be taken into consideration. An application for earlier publication could be filled by the applicant. Then fourth step is request for examination. A request for examination to be filled by the applicant or any other interested person within 36 months from the date of priority or filing of the patent application, whichever is earlier. Next step for the patenting the patent in India is pre-grant opposition. Within 3 months from the date of publication or before the grant of patent, whichever is later, any person may file opposition on limited grounds. Opposition is considered only when the request from examination filed. Then next step for the patenting the patent in India is first examination report. The examiner of patent is required to issue a first examination report within 1 month, but not exceeding 3 months from the date of reference. This report raises various substantive and procedural objections. Next step is meeting the official objections. the applicant has to comply with the objections to put the application in order to acceptance within 6 months from the date of report. Could be extended by another 3 months by filing an application to that effect. And last one, grant of the patent. If the applicant complies with objection raised in the first statement of objection within 6 months, then and then only. If the application complies the objection raised within 6 months, that may be extended for 3 months again from the date of first statement. Else, the application is deemed to have been abandoned. This is the process. These are the steps to get any product or process procedure get patented. And last step after granting the patent is post-grant opposition. First opposition is nice. Second one, post-grant opposition. Within 1 year from the date of publication of grant of patent, any person interested may file an opposition on the grounds of enlisted in section 25. Third, can raise the application after granting the patent also. It is very important factor. What do we say? What do we have seen? That what are the steps? What are the head offices? What is the process? What is the procedure? How the product or process or anything get patented in India? These are the steps. Like this, we have summarized the patent because it is the very important factor in science colleges, also in commerce colleges. Professors and associate professors, also assistant professors, they are filing their patents and getting approved or getting granted using these steps. And this is a very important asset for that institution to getting the patent to any individual or an institution. Next, IPR. Next, IPR is a trade secret. Trade secrets. Trade secrets is any intellectual work or product used for a business that can be classified as belonging to the business provided it is not based on information in public domain. Trade secret is something that offers an advantage in business if it kept as a secret. There is no need to come this in public domain. It is a secret. But then also you have to get registered these trade secrets. A trade secret can be a client list, a formula for a product, etc. A trade secret does not have to be a patentable, but it must be capable to being maintained. For instance, a client list can be protected by computer passwords, and the formula can be safeguarded by disclosing it to a limited number of people. Trade secrets are not registered with any government or other agency. Like patent, there is some difference between patent and trade secret. Secret is a secret for that company, for that institution, for trading. But patent is open for public domain. Trade secret is not open for public domain. It's a secret or confidential document of that particular institution. Now we will see what is the copyright, because As like the patents for the science faculty, there is a need to discuss copyright, particularly in social sciences. This copyright is very important factor because in social sciences, there is a literary work, there is dramatic work, music work, artistic work, and that's why it's important for social science friends, social science professors, that copyright will exclusive right to do or authorize others to do certain acts in relation to literary, dramatic, music, and artistic work. What it includes? It includes books, it includes cinema or TV programs. Also, it includes sound recording. For these products, copyrights is essential. Permission is needed to reproduce the copyrighted material. No one can reproduce the material without getting permission by the owner. Application to be made to the Register of Copyrights at New Delhi. Like patent, there are for patent there are 4 offices. For copyright, we have to apply at the Register Copyrights at New Delhi. What is the term of copyright? Author's life plus 60 years for books. Validity of the copyright is about the book, that is the life of author plus 60 years additional to the life of author. For films and photographs, 60 years is the validity period of copyrights, and 25 years is the valid period for broadcasting. It protects the publications of the studies. Information provided by the drug companies may be protected by copyright law. Compulsory license can be given under a section 31. What are the copyright laws? We will see what are the copyright laws. As per section 1 of part 2, GATT copyright laws cover the following. Also here we have to clear that it is the international scenario about copyrights. First one of reproduction, that is exclusive right to make copies of work. For the purposes of this right, a copy of any work can be in any form in which the work is fixed and from which it can be perceived, reproduced, or communicated either directly or with the help of machine. For example, we get the Xerox copy of any book. It is not fair because the right for a reproduction is given to the owner of that particular work. Right for modification and adaptation means what? Some work is there and we have no right. Only the owner has a right to reproduce it. Exclusively rights to modify and make adaptations and create derivative works. A work in a different medium such as films as compared to a book is an adaptation or a derivative. This suppose there is any book. On that book, there the film shall be released, but there is authority. There is authority to the owner whether that has to be given for the film process or not. That authority is with owner only. Then third one is right for distribution. That is the right distributes to the public, and right for public performance. That is the right to recite, to play, dance, or act with or without the aid of machine. This is the scenario international about the copyright law. Who has the authority to reproduction? Who has the rights for modification? Who has a right for distribution? Here, there is a distributor, there is a publisher, and there is an author. As per the rules set by government, as per the rules set internationally, that has to be obeyed by all these three stakeholders in copyrights. That's owner, means author, means publisher, and means distributor also. It is the mandatory to stick up for the rights given in the copyright law. Then what is the exception? Is it the violence of copyright in the following manner or in the following process? We say there is a fair use of books, then we can Xerox it, we can reproduce it. So there are some exceptions of copyright also, that libraries and archives are permitted to make up the three copies only of unpublished copyrighted work for the purposes of preservation, security, or for deposit the research use in another library of archives. This is the exception, means we can reproduce the three copies only of that particular work for the fair use only in library and archive centers. Second one is for fair use. What is fair use? The definition of the term fair use needs to be explained in the light of the following factors. How we say this is the fair use? It should be used for no profit educational purpose only. Means we can reproduce, student can reproduce, or professor can reproduce, but the distributor or a bookseller cannot be, because distributor and booksellers reproduces it for profit purpose, and it's not a fair use. It should not be commercial purpose. Then nature of copyright work, and whether the whole work has been copied or small part of the work is copied. In some pages we can Xerox from the original book, or only we can reproduce that by using the machine. Small portion or some extent portion of that particular work can be used as a fair use. And last one, the matter of disposition of a particular copy. A copyright is limited by the first tale, according to which the owner of that particular copy of a work may sell or transfer that copy. This is the who is the creator, who is the publisher. He has, or he or she has authority to reproduce. This is the exceptional case. Means what? For fair use, student or professor can reproduce. Libraries and archive center, and the first publisher, first owner, he or she has also an authority or given the exceptions to reproduce the work that has been published earlier. In this way, both patent and copyright, we have seen in detail how the IPR works on these two parameters. Now this one, the design act for each and every 6 or 7 IPRs are there, and act for these 6 or 7 IPRs, dates are varying. 1956 for copyright. Now for design, the rules are 2001. On the base of needs, is there a need? Laws are formulated, and like this is going on process in our country. A design refers to features of shapes, configuration, pattern, ornamentation, composition of lines or colors applied to any article in the 2 or 3-dimensional or both forms. The design refers to the feature of shape. How should be the shape? How should the configuration? Pattern, how? Ornaments and composition, colors applied. These are come under the design of any good. The protection. आवाज येत. Protection. आवाज येतोय, आवाज मॅडम. The protection only for the appearance of the article and not how it works. The design registration protects designs having industrial or commercial use. Designs of stamps, labels, tokens, cards, or cartoons, and part of an article sold separately cannot be registered. Which can be registered and which cannot be registered. A design refers to features, shape, configuration, pattern, ornaments, composition can be registered, but designs of stamps, labels, tokens, cards, cartoons cannot be registered in according to this Design Act 2000 and Design Rules 2001. What is the duration? Duration of protection, the design is 10 years and can be extendable for another term of 5 years. Duration is 10 years and can be extended up to next 5 years. What is the trademark? This is the another type of IPR. Trademark can be a word, trademark can be a name, trademark can be a brand, trademark can be a symbol, can be a label used by a company to create unique identity for their product. For example, there is a patent of glucose. There is a patent for the product, but there is a trademark. Small baby is there, it is a trademark. It is a patent given to that product. Mobile, Apple, there is a symbol of Apple. That is the trademark of that particular product. Means trademark is a design. That is a design that can be distinguished the goods of one trader from those another. From those of another. This is the unique feature, unique identity of their product. This is not similar to any product which is available in market. It includes words, it includes logos, it includes pictures, It includes combination of all these words, logos, and pictures. A trademark is used as a marketing tool for product positioning. The consumer will rely on the labels attached to the product with certain expectation of the quality of said product. The register a trademark, the mark must be distinctive and not contrary to law or morality and not identical to the earlier mark for the same or similar goods. The notion R may be used for the trademark only if it is federally registered. The registration validity of trademark is 7 years and renewable after expiry of these 7 years. Next, a type of IPR is geographical inductions. Geographical Inductions Act 1999, what it gives, what it reflects, what it says. An induction used to identify agricultural, natural, or manufactural goods originating from definite territory of India. It should have a special quality or characteristics or reputation based upon the climatic or production characteristics unique to the geographical location. The registration of geographical induction is from a period of 10 years and renewal is possible for further period of 10 years each. Some examples are there of geographical indications in India or abroad. That is Darjeeling tea, first registered geographical indication in India, which is in Himachal Pradesh. Mysore silk, we say it's a favorite, it's a particular, it's a unanimous. It's only the product Mysore silk, which is in Karnataka. This is the geographical indication registered by that state. Then Kutch embroidery from Gujarat, Feni from Goa, Bikaneri Bhujia from Rajasthan, Tirupati Laddu, Andhra Pradesh, Nagpur orange from Maharashtra, and Scotch whiskey from United Kingdom. These are some examples registered geographically, geographical indications. This is the patented, this is the favorite that is only given to that particular area or that particular product. All these 6 types of IPR we have seen, that is patent, copyright, trademark, trade secret, geographical indications. Like this, there is a law, a act for the protection of plant varieties and Farmers Rights Act 2001. Farmer who has bred or developed a new variety shall be entitled for registration and other protection under PPV and FR Act 2001 in the same manner as a breeder of a variety. Farmer can also develop or breed or get it approved from the government that it's their product, which is a favorite of them only. The duration of protection, farmer can get protection from the registered office of government of their breeding or of their product by applying like breeder and variety of breeder. The duration of protection of register variety is different for different crops. Trees and vines, 18 years period, and other crops, 15 years period. For extant varieties, 15 years from the date of notification of that variety by a central government under Section 5 of the Seeds Act 1966. This is also may not be included in the type of IPR, but it is very essential factor that the protection for plant variety is given by Act 2001, and farmer can get protected his product or get protected his crop by registering this information and get it sanctioned by the government. Traditional knowledge. We know traditional knowledge is passed from one generation to the next, mythically, mostly by orally, from and sometimes in written form. The knowledge comprises innovations, information, practices, customs, traditions, etc. The knowledge may be with regard to the use of natural resources, environment, plants and animals, curing diseases, or nature in general. Most of the knowledge is undocumented. Traditional knowledge is undocumented. It passes from one generation to next generation mythically or by orally. It is not documented. That's why there is a problem for patenting. For example, some leading cases are there. Basmati rice. All of us know what is the case of basmati rice. Neem, controlling fungi in plants by using neem oil. Turmeric for healthy wounds. USA get the patent of these products. USA patent granted for these products, but India succeeded stating it was prior knowledge in India. It's not documented, it's undocumented, and that's why there is a space, there is a chance to get it patented by another countries. So the information, it's a very necessary or essential factor that information should be documented properly. Now, what are the some latest issues in IPR? Maybe in India or abroad. Some latest issues in IPR: cyber squatting, using a domain name with bad faith intent to profit from the goodwill of trademark belonging to someone else, not their own, but belonging to someone else, using a domain for profit purpose. It's also a latest issue of IPR, because today is the age of computer, age of internet, and there is a number of cyber crimes, cyber misbehaves, and in that factor, it comes that the issue of IPR also a factor or a thing to discuss here. The cyber squatter then offers to sell the domain to the person or a company who owns a trademark content within the name at inflated price. Inflated price. Not belonging to own, but it belongs to someone else, but offer to sell the domain with maximum price. It's a very big issue to discuss in this webinar. This is the summary that India's IPR policy, how it ran from 1957 to till the date. That is, in 1957, the Copyright Act has been created. 1958, Copyright Rules. 1970, the Patents Act. 1999, International Copyright Order. 2000, the Semiconductors Layout Design Act, the Design Act 2000. 2001, the Design Rules. 2002, GI rules, Geographical Indication Rules, the Biological Diversity Act. 2003, the Patent Rules. 2004, Biological Diversity Rules. And 2010, IPBB rules and procedures. In short, what is the India's policy in respect with the IPR? It is a globally acknowledged fact that India's existing policy is for Indians as well as for the peoples from other developing countries. It has been globally acknowledged fact that not only the individuals living in India, but the people who are abroad from the India working in development countries are also can get IPR from our government, Indian government. Then Affordable Care Act, which is the act in USA in the period of Obama. And after the frequently visits of Modi and Obama, USA has been promised for investment for the IPR because the status of IPR is not very good in India. That's why USA is interested or promised to invest about IPR to enrich the quality and to get it filed, to get it documented, to get it IPRs. USA has promised us. The attack on India's IPR became intense after 2012. 2012, after that, India's IPR became intense. India is on priority watch list in America's special 301 report that identifies countries which do not provide adequate and effective protection for IPR. India also come in these 301 countries, and that report indicates that we have to enrich, we have to enhance the IPR policy in India. Now, how to enhance the quality of IPR in India? That is by central government and UGC's Code of Professional Ethics, UGC Guidelines 2018, UGC Regulations 2018, guidelines given for the research purpose to the professors, what are the responsibilities, what are the duties, what are the ethics about research, and about the work done by the professor. It has been cleared in the regulation of UGC 2018. What it gives? It gives teacher responsibilities. What is there are number of responsibilities like teaching, evaluation, and all these things. All of us knows. But that in this respect of that webinar, there is one responsibility given in UGC guideline, that is the prime duty of professor is research. It's a part of duty of professor to research is mandatory for the professor. And another expectation or another part of duty of the professor is to discourage in plagiarism. Discourage in plagiarism. Then what is the plagiarism? Plagiarism is the appropriation of another person's ideas, processes, results, or words without giving appropriate credit. Without giving appropriate credit to the owner of that particular idea, of that particular process, or that particular results or words. This is the plagiarism. There are three types of research misconducts. What are these three types? First one, plagiarism. Plagiarism is misconduct in research. This is because we are taking the copying the fake information of another person and telling that information is its own information, and this is the plagiarism. It is the appropriation of another person's idea, another person's process, another person's results or words without giving appropriate credit. Means what? We are not citing the owner of that idea. We are not giving the credit to the owner of that idea. That becomes a plagiarism. Then second research misconduct is fabrication. What is results of another else, results of another else, you are taking that results and supporting that results using your study. And fabrication, it's also a misconduct in research. What is the third type of research misconduct? Falsification means manipulation in research materials is also a misconduct in research. And what UGC expect from us, that we should not misconduct all these types in research because we are learned society. We are professors. We are part of society. We are creator of youngsters. And that's why it's expected by the UGC or central government that you should not be misconduct the research. Then what are the common forms of plagiarism? Because maybe these three misconducts are there. Most important type of the misconduct of research is plagiarism. And in this era, in this digital era, it has become very easy to plagiarize the document, as we are just going to Google, searching some information. We are not evaluating that information, taking it as it is, copying that as it is, and giving that information in your own work, saying that it's my information. Nowadays, it's very, very critical problem facing by the research community, that in this digital era, it is very easy to copy the material from Google, from any search engine, and taking that information, copying that information, putting it into your own work and saying that it's my information. So common forms of plagiarism is a factor to discuss here, because this is the practice day by day increasing in research era. How it takes place? It takes place by using someone's ideas without referring the author. When we take someone's idea and refer to him or her, then it becomes a fair use of that information and not a plagiarism. But without referring the author, without referring the owner, we are putting that information, using that someone's idea and telling that ideas are own ideas, that is the plagiarism. Then someone's presenting someone's work as your own work, it's also a common practice in plagiarism. Copying from a source without acknowledgement. Without acknowledgement, copying the information from any resource of information is also a common factor in plagiarism. And last but not the least, very important factor is that in plagiarism, self-plagiarism. We are publishing number of articles, number of books, number of papers, and in next paper, you are using the same data, which is yours data. Maybe that data is yours data, but once it has been published, that has to be acknowledged. That has to be acknowledged. Otherwise, it also becomes a practice of plagiarism. Nowadays, it is a fact that number of students, number of researchers, number of youngsters, new researchers, young researchers are coming for research, but they do not want to give any time or any efforts for the good research, and that's why this practice become a popular practice, that is the plagiarism practice. As per the UGC guidelines 2018, there is a punishment for the plagiarism. What is the punishment for plagiarism? It's a different for researcher and different for the for students and different for the teachers. As per UGC guideline 2018, if the thesis has been submitted by the researcher and if there is 10 to 20% plagiarism, then what is the punishment? That should be resubmitted. Thesis should be resubmitted. If the plagiarism found 40 to 60%, then what is the punishment? Punishment is deprived to submit a revised thesis for 1 year. Means he or she cannot submit his or her thesis within a year. He or she should wait for 1 year. It is the penalty, it is the punishment about the plagiarism. And if there is more than 60% plagiarism, then the cancellation of research registration permanently. This is the fact, this is the act, this is the guideline of UGC, that if the 40 more than 60% plagiarism exists in the thesis, then the registration of that particular research will be cancelled permanently. Then what about teachers? Any teacher has been published his or her own material which consists of 10 to 40% plagiarism, then he or she should withdraw the manuscript from the publisher, maybe the e-publication or maybe in the form of hard copy, and he or she debarred from the guideship for 2 years. Means the teacher cannot guide to the UG student, to the MPhil student, as well as the PhD student for 2 years if the 10 to 40% plagiarism has been found in their works which has been published. If the 40 to 60% plagiarism found in the work of the teacher, then what is the penalty? There is penalty that denied to a single annual increment. Annual increment may be stopped for 1 year. This is the monetary punishment for the teachers. And very last one, if the original work or work published by the teacher found the plagiarism more than 60%, then University Act or UGC guidelines what indicates for suspension and dismiss. Unfortunately, actually, this is not the platform to give the names of all the persons, but unfortunately, working in higher education on very respected position, they some people have been suspended on this regards of plagiarism in their published work. Means what? India's policy maybe the universally said that there is a need to work on plagiarism or IPR in India. India is consistently taking effort to enhance the quality in research, and it's the result of that efforts that UGC is punishing that particular peoples which are not ethically sound, which are not doing their research properly. And this is the way, where we are enhancing our research policy. In this new education policy also, there is a sound importance given to the research, cluster universities, and all these things. That's why we are step by step going to enhance our policies. Actions are taken against the plagiarism. There are some examples that the persons having high profile and working on very respected positions have lost their jobs due to the plagiarism in their work. Obviously, all of us are about this situation, what is going on. But we have to percolate this information to the young researchers to prevent the plagiarism in their work, and all professionals to take the right of our intellectual property. That what is the summary of my presentation? We should take care. We should take care the right of our intellectual property. We should take care of plagiarism. We should stick up the government and UGC guidelines. We should obey the professional ethics, and we should circulate the same information which we are using to the younger researcher to avoid the complications in their research work. It's our duty. It's our duty to percolate this information. What is the fruit of this webinar? If we taken into consideration all these 5 points, obeying these all points in our research work, and percolating this information to our research answers, our students, is the fruit of this webinar. Thank you very much to the principal of the Borowicke College, organizing team of this webinar, Dr. Anankar sir, Desai madam, for giving me an opportunity to discuss these my views with you. And thank you very much to the audience, learned audience, by listening patiently me. Thank you very much. Over to you, Desai madam.
Thank you very much, madam, for giving the insights about the intellectual property rights. I want to ask the participant if they have any questions related to this. They can write in the chat box on Zoom. Any questions? Okay, so now we are moving towards the last session, that is the vote of thanks. I request Dr. Anandkar sir to give the vote of thanks. Okay. One question is there. Can I fill trademark strike of company from Priya Shahu to everyone? Ma'am,
Please,
can I fill trademark strike of company? You can.
Yes, we can. Yes.
Okay.
Yes, trademarks. We can fight.
Okay. So now over to you, Anandkar sir, for the vote of thanks.
Members such as Dr. Rajendra Kumar sir, HOD and Professor, Library and Information Science, Sanjeev University, Dr. Sanjay Mansur sir, Dr. Shubhra Vedakar, Madam, Dr. B. DKD sir, Director, Marketing People Center, Dr. Baba sir, Ambedkar Maratha University, Aurangabad, Dr. Vaishali Kapadekar, Professor, Library and Information Science, Dr. Baba sir, Ambedkar Maratha University, Aurangabad, and others such as Dr. Rajendra Balai sir, Vivek Mure sir, and Indra sir, etc. Thanks to all participants from all over India and abroad. Thanks to Dr. P.V. Bardesar, IQSC coordinator of our college. Thanks to teaching and non-teaching staff of our college. Thank you to technical experts such as Dr. B.S. Lindesar and others. Thanks to Dr. N.D. Desai as chairman of Intellectual Property Lifestyle and other member of IPR cells of our college. And once again, thank you to each and everybody who helped for organization of this webinar. Okay, thank you. Once again, thank you. And now we will provide our feedback link to you.
Okay, we will send the feedback link to the Telegram group, and then you can fill the feedback form, and then you will get the e-certificates. Okay, thank you.
एंड करायची होती
Thank you, each and every.
करू एंड फायनलला काय बोलायचं आहे नाही ना